Welcome to this video on the Parol Evidence Rule. I'm Professor Seth C. Orenberg, and as someone who teaches contracts for a living, I'm well aware that the Parol Evidence Rule is pretty tricky for a lot of students. So I made a flowchart to help you understand it, and then I made this video to help explain the flowchart, and I'm hoping that inside of about 10 minutes, you can use this as a helpful review to remind yourselves how to perform on a bar exam or a contracts exam or in practice when you're presented with a problem involving the Parol Evidence Rule. The first step is simply understanding when the Parol Evidence Rule is likely to apply. First and foremost, there will always be a written contract. The Parol Evidence Rule only applies when there is a written contract. If there's no written contract, the Parol Evidence Rule is not applicable to the problem. In addition, the fact pattern will indicate that one party will be introducing extrinsic evidence, most commonly preliminary negotiations, a conversation the parties had before the contract was formed. And third, this evidence would add a term to the contract or modify a term in the contract. If those three elements are present, it's time to begin the Parol Evidence Rule analysis. That analysis unfolds in two steps, although it might be helpful to think of the first step as having two subparts, and effectively we're asking two questions that pertain to the two steps. The first question is, what is the nature of the contract? Here we're trying to determine if the writing that we're analyzing is a final memorialization of the parties' terms, or if it's merely a draft. If it's a draft, there is effectively no final written contract, and the Parol Evidence Rule does not apply. Once we've determined the contract is at least final, we would then ask if it's more than that, if it's a complete and total integration of all of the parties' terms. Once we've determined the nature of the contract, we then ask in step 2, what is the nature of the evidence? What does the evidence seek to do? Is the evidence seeking to modify a term, to add a term, or for something else? Now that we have assessed the nature of the written agreement and the nature of the evidence to be introduced, we can determine if the Parol Evidence Rule will or will not prohibit introduction of that evidence. The Parol Evidence Rule really only does two things. The Parol Evidence Rule bars evidence that modifies a final agreement, and it bars evidence that adds to a complete agreement. We might also note the Parol Evidence Rule does not do any of these things. The Parol Evidence Rule does not bar evidence of the meaning of an ambiguous term. In other words, the Parol Evidence Rule can be used to clarify a term, which is different than adding or modifying a term. Check out my other video on the difference between the objective and subjective theory of contract interpretation, but some courts will also allow extrinsic evidence that will show there is a latent ambiguity. In other words, Parol Evidence Rule might not apply and might not prevent the introduction of extrinsic evidence which shows the contract is susceptible to another meaning, even if it's not patently ambiguous on its face. The Parol Evidence Rule also does not bar evidence of course of performance, course of dealing, and usage of trade, at least if the contract is governed by the Uniform Commercial Code. The Parol Evidence Rule does not bar evidence of collateral agreements, and you can watch my video on collateral agreements to try to understand how we distinguish a collateral agreement from one which is part and parcel of the contract at issue. And finally, the Parol Evidence Rule does not bar evidence of defects in contract formation. After all, if the contract was not really formed, there is no final or complete written agreement after all. So the Parol Evidence Rule will not prohibit parties from introducing evidence of mistake, misrepresentation, duress, undue influence, anything that suggests the contract was not really formed. Last but not least, please remember to spell parole evidence correctly. There's no E in this parole. Now, let's go ahead and get started with the flowchart. And by working our way through this flowchart analysis, I think you'll gain some clarity on how to apply the Parol Evidence Rule and understand its ramifications. We're going to read the writing and look at its intrinsic evidence. So does it say on it
draft for negotiation purposes only. Well, that's pretty good evidence. It's not final. Does it say final execution version? Does it contain a merger clause? When you read the contract, what does it tell you about itself? That's our first step. Now we ask, is that intrinsic evidence clear and unequivocal? Are we sure that it's final based on reading it? If we're not sure, even an objective court will admit additional extrinsic evidence. Right? Because it's ambiguous. If the contract is ambiguous on its face, any court will admit extrinsic evidence to clarify the ambiguity. So we go down. If the contract is potentially ambiguous, then we're going to look at extrinsic evidence. And we see, what does the extrinsic evidence say? And we balance the two. Even if it's unequivocal, a court can still admit extrinsic evidence if they prefer the subjective view of contracting. And so that's our step here, right? Even if we find it's unequivocal, subjective courts will often still hear extrinsic evidence, and that will lead them to one conclusion or another, either that it's final or the extrinsic evidence will show the contract is a draft. Every contract that's final, that's complete, is also final. So we can start by determining finality and then ask, on top of that, are we going in the smaller Venn diagram circle of completeness? This will ensure that we've correctly identified the contract. So here we follow this chart and we ask, does it contain intrinsic evidence or extrinsic evidence that leads us to think that it's final or a draft? If it's a draft, the Parol Evidence Rule doesn't apply and we're done. If it's final, we then need to figure out whether it's final, merely final, or complete and exclusive, whether it falls in that narrower Venn diagram of complete and exclusive and final. First thing to look at is look for a merger clause. Now, as Alec pointed out, a merger clause is not essential. It's extremely helpful and excellent evidence, and the absence of a merger clause is very good evidence that it's not intended to be an integration. But as I put up here on the chart, even if we don't have a merger clause, we can still look at extrinsic evidence if the contract is ambiguous or if the court likes to take a subjective approach. And for that matter, as we saw in Sierra Diesel, even if the contract is unequivocal, the court might still take a subjective approach and ask what the parties intended. We will then assess, based on what the contract said and maybe what the parties did, if the contract is a complete integration or whether it is merely final. Now, let's put that aside because we've now resolved at the end of step 1 the nature of the contract. Step 2 asks, what's the nature of the evidence to be introduced? Several types of evidence are not subject to Parol Evidence Rule. And so this is like a knockout flow chart. Basically, I step us through 4 processes that each of which independently would knock us out because these are all things that the Parol Evidence Rule does not apply to. First, is the evidence introduced to show defect in formation? If so, that's a defective formation issue and it will not be prohibited by the Parol Evidence Rule. Second, is it introduced to explain an ambiguous term? We can always explain patently ambiguous terms, and we might be able to explain latently ambiguous terms in a subjective court. And in addition, if we're dealing with the UCC, we always admit course of performance, course of dealing, and uses of trade to explain terms if it's a UCC contract. And so all of that evidence will come in as well. Any subsequent modification will also come in because parties are free to modify their agreements. Now, we can evaluate that under the pre-existing duty rule to make sure that if it wasn't supported by sufficient consideration, it meets the other standards required there. But if it's an evidence of subsequent modification, it's not a Parol Evidence Rule issue, and so it gets knocked out. And finally, we can ask, does the evidence pertain to a separate agreement? Is it collateral? And as we saw in Seagram, it's very fact-specific, and usually it should jump out at you one way or the other, but that's another way we can knock out the term, not apply the Parol Evidence Rule to bar it. We knock out the term from the Parol Evidence Rule, which means it gets included. I know, it's a little meta, right? The Parol Evidence Rule is a rule of exclusion, so being excluded from the Parol Evidence Rule means it's included. Okay, that's on the tape. You can think that one through. Right? And so finally, if we've made it through all of the knockout rules, we then will ask, okay, is this going to modify a term or is it going to add a term? And now we've resolved as to the nature of the evidence to be presented, and we can finally integrate our understanding with this chart and determine whether or not the evidence comes in or does not come in. So if we have a contract that's complete and exclusive, it will bar evidence that adds or modifies a term. That's the Parol Evidence Rule regarding complete and exclusive agreements. The agreement is complete and exclusive, therefore it will not be subject to changing or adding terms. Of course, it will admit evidence of defective formation, subsequent modification, explaining a term that is ambiguous or required by the UCC, or evidence of a collateral term, because the Parol Evidence Rule does not apply to those. If we find that we have a partial integration, right, then we would admit evidence that adds a term because it's not complete, it's merely final, but we will exclude evidence that contradicts a term. And of course, we will also admit evidence of defective formation, subsequent modification, evidence used to explain a patently obvious term, maybe evidence to show a latent ambiguity, and if it's a UCC contract, we will also admit evidence of course of performance, course of dealing, or usage of trade. And finally, if the contract's just a draft, the Parol Evidence Rule doesn't apply either. If you got a draft, well, it's not final, and so the Parol Evidence Rule also does not apply. And so there you have it. That is the Parol Evidence Rule in a really big whopping nutshell.